It's 2 o'clock. Good afternoon. Today's date is March 15, 2019, and the time is 2 p.m. This is a time and place for Del Norte County administrative hearings conducted by a hearing officer. I'm Robert J. Drossel, attorney at law. I have been duly appointed to act as a hearing officer for these proceedings. These proceedings are recorded, so as all statements must be made from the podium in front of me. When your case is called, please come to the podium. I will ask for you to state your name and spell it. Please speak clearly and loudly. The county will present its case first. You will then be given an opportunity to present evidence and question the code enforcement officer if you desire. You will first be sworn in. Please make sure that all cell phones, pagers, or other devices are turned off or set to silence. If you need to make a call, please step into the corridor so that you will not disturb these proceedings. And so we're ready to get to the calendar. Actually, we have 8 cases on today, and I see some people are here. And why don't we take the Dennis Sutton case first. That's number 6 on the calendar. 371 to 391 Darby. This is the Dennis Sutton case. As to, you can have a seat right on the front bench here, or the front row, and when we're ready for you, we will call you up again. This case is on for a progress hearing. A little history here. On July 20, 2018, an administrative hearing was held on public nuisance issues at the property indicated. After the hearing, a order was issued stating that there was a public nuisance and order to abate that nuisance within 90 days. Since July 2018, there have been 3 reviews so far to see how we're doing with compliance. I know one issue has been the weather. It's hard to work in those situations. However, there is been some good weather also. Last hearing was on February 22nd, 2019, which at least 5 people from the public sector gave their opinions on the status of the property and what they wanted out of it. So first, let me swear in our code enforcement officer, Dominic Melo, and that will be good for all the cases on calendar today. Sir, do you solemnly swear or affirm that the testimony you are about to give in these proceedings, now pending at this hearing, will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes, I do.
Thank you. And do you agree with the assessment I gave so far on the status of where we are on this Dennis Sutton case?
Yes.
Okay. And you were present at the last hearing. Do you have any additional information to report at this time?
Just over the last course of the month since our last hearing, did a lot of communication with the property owner and some of the complainants, just trying to work out a palatable situation for everybody, a resolution that would work. And then today I have received a written letter from a complainant I'd like to submit as an exhibit.
All right. Do you have that?
Yes.
Please? This will be marked as Exhibit 1 for today. It's from a Rick Hardy. Is there a Rick Hardy present, by the way? No. I'll go ahead and read this. Its date is March 13, 2019, to whom it may concern. I'd like to take this written note as a documentation and concerns for the property on Darby Street. I understand the property is owned by Dennis Sutton, who does not live there. Property in question have at least 3 large vacant for years mobile homes parked on it. These 3 mobile homes and the entire lot are typically covered with unmaintained and overgrown vegetation. There are several unmaintained and neglected properties in this rural residential area that fall under this and similar circumstances. My family and I have purchased a home and have lived in this area commonly known as Birch Tract for 20 years. In those areas, I have done several additions and improvements on my home and property. After these improvements, I elected to refinance my mortgage only to discover my home value had remained the same or dropped in value. It's been expressed to me several times by real estate agents, home inspectors, and appraisers that property values in this area are directly affected by unmaintained and neglected homes and properties. It's a shame that Mr. Sutton does little or no upkeep on this property, allowing it to be complete eyesore that is detrimental to the others forced to live in this neglect. I believe the county needs to step in and do something with these neglected properties so the rest of us are not forced to live with the obvious blight of these situations. Time to clean up. It's signed by Rick Hardy. All right. It seems to be the prevailing view as expressed by the witnesses at last hearing. So we're here for a status review, and I can tell you this, that not only the code enforcement officer, but the goal here is to get compliance and to make sure that there are no health, safety, or welfare issues involved, and people can live peacefully in that particular area without public nuisance affecting them. So having said that, I'd like to hear from Dennis Sutton, sir. And I should, I guess, swear you in. Sir, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you are about to give in these matters now pending at this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you, sir. Do you, are you prepared or to give us some information as to the status of the properties involved here?
I have a statement or two and some questions. What are the health and safety problems that I have?
Well, that was indicated on the order that was issued. You were here on July 2018, and we went through that process. There were evidence existing that was put into evidence, including multiple photographs. And if you want to give me the order again on the Sutton case, do you have it handy?
The notice of nuisance?
No, the order that I signed.
Yes, I can get that.
While we're waiting, I've never known of anybody living in there other than when they were paying me rent or living there without paying me rent. One of the mobiles was lived in by a man that built a house on Ames Way. He lived in there for over a year while he was building a house on Ames Way. Some of the people I listened to the recording, some of the people said nobody had ever lived in there. All 3 of those trailers were rented for quite some time. One of the neighbors shot out the front window on the center mobile, and the tenant moved out the next day. It happened to be the one on the corner, kitty corner, that said he lost $20,000 on his house because of the mobiles. I've had the building secure, and every time I go over there and they're unsecure, I put 2-inch screws back in the doors so people can't get in. I see where there's no, and there was overgrown, and I put my back up. They were all livable when the last blight guy pulled the power, had the power company pull my power. Since then, they've gone downhill. Now, I had somebody offer me $25,000 for 3 buildable lots because of the area that they're in, not because of my mobiles. They said if I take all 3 mobiles off, they'd give me $25,000 for all 3 parcels. That's because of the neighborhood they're in, not because of my mobiles. There's way more people over there that have worse property than mine, and nobody says anything about those. Those mobile homes cause problems the day I put them in. A lady showed up and said, I'm going to fight those and get those off, and she did for years. I agree, they don't look right setting like that, but when I bought those mobiles and I got the permits, they were set to go perpendicular to the road, not parallel. The day before they came, Ernie Perry called me and told me they had to be turned. I said, that's not, he said, well, you can apply for a variance, but it's going to take at least 6 months and you're not going to get it. Ernie Perry told me that. So I put them that way. I was going to build a little garage next to them and make them nice little parcels. I've had a problem ever since. And on the ditches, they said last time I listened to the recording, they said the ditches had berries. Well, we're not responsible for the ditches. The county is. The blight guy sent me a letter, told me I had to clean the ditches. I cleaned them for 5 years. I called the road department and said, can I put a culvert in so I don't have to? And he said, no, you can't have a culvert, but we're responsible for the ditches, not you. I'm not.
Well, if I think I get the gist here. You have to understand, Mr. Sutton, that we did go through all this at the public hearing. And by the way, that since July 20, 2018, the 90-day appeal period has already expired, so the order is going to stay. And that order was that the way the property was located and the things on the property was unsafe, substandard, detrimental to the health, safety, and welfare, overgrowth of vegetation, constituting rodent harborage and fire hazards, etc. Constitutes a blight, visual blight, accumulation of personal property, objects or structure, unsightly, etc. 200 more square feet of the area. For lot or storage, keeping of junk, including scrap metal or other scrap metals. Vacant, unoccupied or abandoned buildings or structure that is not reasonably secure against uninvited entry, etc., etc., etc. So, and then again, to refresh your recollection, the order included the abatement shall consist of the following: remove and properly dispose of all junk, debris accumulations, properly cut, mow, or prune as necessary to eliminate overgrowth or vegetation. All dilapidated or unsafe buildings shall be demolished or rehabilitated. All dilapidated or unsafe buildings and structures shall be vacated and secured against any entry until they are either demolished or rehabilitated. So I think the order was quite clear. And by the way, so there's no confusion in that the hearing we had on July 20, 2018, the burden is just by preponderance of evidence. That's like 51%, so that was quite easily to rule on that case. It's not like in criminal law where you need a beyond a reasonable doubt type thing, where this is a civil process. So preponderance of the evidence certainly prevailed at that hearing. Now, you mentioned at one time you had a permit that gives you authority to do something, i.e. place a structure, mobile home on that property, and that's fine, but a permit does not give you permission to let the property dilapidate, so you can't rely on that basis. And so here we are again at third or fourth review, and I need something substantial to show that you're making progress. The county could be in a position to go ahead and take care of the problem, the county expense, and then you're going to be given a bill for that on a cost recovery basis. So I need something to show that there's progress being made, and it looks like it's happening way, way, way too slow. So I need to hear from you what you're going to do. And if you're not going to do nothing, the county's going to come in and take care of the problem.
Okay, they were my retirement.
Yes, sir.
Now they need to be rehabbed because when the power company pulled the power because the blight guy asked him to pull it, I kind of put my back up, and they've gone downhill ever since. If I rehab them, am I going to leave them there, or am I going to have to remove them like you're requesting? Can I rehab them?
We've given you time to do either one, demolish or rehab.
I'm under the understanding that if I rehab them, you're still going to make me take them off. That's what I got from the first hearing. I'm going to go to the state and see if I can't do something about it. I can't see how you can make me take those off if I rehab them. That's what I'm asking, and that's
What progress have you made, Mr. Sutton, to rehab? Tell me some things, 1 through 5 or whatever, what you've done to rehab.
I spent $10,000 taking that one trailer off.
Yes, you
and
have.
Getting the other ones all mowed and cleaned up and secured again. I resecured them every time. I had to resecure them after we went out and looked the other day. Somebody'd been into them again. There's people going in there. I've asked the neighbors to call me so I can get the cops out there if somebody's in. If I rehab them, am I going to be able to leave them on there?
Depends upon what your quality of rehabilitation is and whether it meets the
state has to inspect them.
Code.
The state has to inspect them. I have to get a permit from the state. I've talked to them, and I'm waiting for some hearing from them on to get the permits to rehab them. If I rehab them, am I going to be able to leave them on there? And rehab to the state specs.
If they meet state specs and there's no longer any public nuisance, and we'd have to have the county officer.
I want to know what the health and safety is. It's the aesthetics is the problem that I'm having a problem with. They don't want them there. If the state says that I rehabbed them okay, am I going to be able to leave them there? Why should I spend the money and then you're going to say take them off anyway? This is what I'm hearing here.
You can, sir, if you think you're unaware of what the nuisance is, you can look at section 8.120 and the following sections of the Del Norte County Code, and it goes in through a whole number of nuisance factors.
There's no rats. There's no overgrown stuff. I got rid of the overgrown stuff.
And that's 8.310 also.
8.310?
Yes, sir. And the outlying sections thereabout. So you're still giving me what you'd like to do, and but nothing's been done, and this has been going on since July. And
Mr. Drossel.
It's also my understanding that the neighbors have offered to help you out.
Not to me. They haven't offered to me.
Well, at the hearing,
I heard it, but I was under the impression that somebody was going to talk to me this morning, and nobody showed up to talk to me. So I don't know.
All right.
I was open to a commentary, but nobody showed up. So I don't know.
Okay. Well,
I heard that somebody wanted to smash my trailers down to squat, and I can really do that. Mr. Sutton knows I can do that. I heard it on the tape. So
yes. All right. Well, I don't know if things can change. I don't know if that is still a possibility, or you're interested, or even interested in it. Let me put it that way.
I'm open to take care of the problem, but they were my retirement. You're taking my livelihood, and it really upsets me to tell me I got to spend another $30,000 taking those trailers off there. Plus, I'm losing my livelihood too.
Well, you've given two choices to take care of the problem: demolition or rehab. And you demolished one, which is great. That's why we continued with the progress hearings here to see what's going to happen on the others. And I need to know if you're talking to me in good faith about a rehab, and you're going to do it on the remaining 3 trailers? Or is this going to go on for years and years, and you're just going to be putting us, you know, continually in a situation here where nothing gets accomplished? Because if that's the case, I'd rather cut it short right now and say, you know, I'm going to have the county, they're going to go in and get a warrant for demolition.
Well, if you do that, I'm going to get a lawyer, and I'm going to file appeals.
Well, your appeal period has run, but you're welcome to talk to any attorney you want to, but at least the appeal period has run on the order for abatement.
I don't have an appeal period? You tell me I have to...
You had 90 days, which was it's also stated in the order, which you were given a copy of on July 20, 2018. You had 90 days for appeal. I can read it right to you here from the...
Well, I believe you. I didn't realize that. I can't appeal anything you decide today. I can't appeal.
It says the decision of the hearing officer shall be final, subject to judicial review in accordance with California Code of Civil Procedure 1094.6, and that basically tells you 90 days. So from that hearing, yes, you have no appeal rights. What we're trying to do now is get compliance.
I want to rehab them.
I'm sorry?
I want to rehab them. I need some time to get with the state to get what I have to do. I'd like 60 days to get figure the paperwork out with the state and get them rehabbed.
Do you have funds to do that, sir?
I can do probably one at a time.
Let me hear from the code enforcement officer. What's your thoughts on this information, Officer Melo?
As outlined in the notice of nuisance, he does have the option to obtain any required building permits to fix, repair, or demolish the dilapidated structures on the property. And I've also had a conversation with the HCD rep that services our area, and so they're definitely rehabable if Mr. Sutton chooses to do that. So code enforcement would just expect to see some substantial steps made to show that he is in fact going to do that. So by obtaining the proper permits would be the first step, and then establishing a timeline of reasonableness of when he's going to complete that.
What do you think, in your experience, to give Mr. Sutton enough time to contact the state, get the necessary permits for rehab?
Permit should be obtainable within a 30-day period. We can just report back in 30 days and check in with Mr. Sutton and go from there.
All right. Before I make it,
I'd like 60, so I can get some time to get a couple of things taken care of and the permits in hand.
All right. And I'm relying on your good faith statements here that is your plan. You're not going to change it in mid-course, that you have the funds to do that, and you sincerely believe that you can rehab all 3 within a reasonable period of time. Is that what you're telling me?
Well, it depends what your reasonable period of time is. If I can do one in like 6 months and another one the next 6 months, and another 6 months after that.
So you want, you're looking at...
If I can do them quicker, I will.
You're looking at 1.5 years to rehab 3.
I have other job and work to do too. I can only do this in my spare time.
Well, maybe you should make it more of a pressing matter. Maybe that's one of the problems here. Before I make a decision on that, is there anyone else who wants to hear that have not stated anything that they didn't state last time? Is there anyone here who wants to give any information? All right. Okay, I'm going to give you 60 days and to start, specifically to start the rehabilitation process on all 3 trailers at 371 to 391 Darby, Crescent City area, and that would be May 17th at 2 p.m. Is that correct, Madam Clerk? Okay, May 17, 2 p.m. status report. And I want to see evidence either shown through our code enforcement officer that you've gotten necessary permits to do that, and that hopefully you'll have some substantial compliance on your efforts. Okay?
Okay, thank you.
All right, thank you. Let's see some compliance. Thank you, Mr. Sutton. All right. The exhibit that was entered today will be kept until this process is completed, and then returned to the code enforcement officer. All right. We'll go to the top of the calendar. Oh, let me get it so we don't get this mixed up with other cases under the file. All right, regarding 243 Olive Street, cost recovery proceedings, Luane Garmin Trust. Is anybody here on that matter? There is no response, so we'll go ahead with the hearing in the absence of the people present. Let's see here. All right, this is a hearing to determine the cost of abatement, cost of administration, and whether civil penalties should be imposed. Code enforcement officer has been sworn in on this case. Mr. Melo, Officer Melo, do you have any evidence to present?
Yes, you have 3 exhibits for the cost recovery today.
All right, you could present these, please. Thank you. Okay, Exhibit 1 is a 2 pages. It appears to be letters to an Amber Peterson and Lance Garman regarding 243 Olive Street, Crescent City, property in question. It appears to notify them of the hearing today, March 15, 2019 at 2 p.m. for cost recovery hearing. Did you hear from either of these parties after these letters dated February 27, 2019? Any response?
I never heard from, I think it's Lance, and Amber hasn't contacted me in over a year.
All right. And Exhibit 2 appears to be a letter to the hearing officer, that's me, and the date of February 27th regarding the nuisance abatement accounting hearing, property 243 Olive Street. And it's a requesting, it's basically a summary and requesting costs to be recovered. And has this been reviewed by the Director of Community Development, Heidi Kunstler? Mr. Melo?
Yes, it has.
All right. And I do see her signature on that. And has, in your opinion, substantial compliance with the order of 8/17/2018 been obtained?
Yes, it was conducted under the service of an abatement warrant.
All right. And says here, cost of abatement of violations of property 43 Olive Street, Crescent City. Notices have been given. Or about November 16, 2018, enforcement officer obtained a abatement warrant from Del Norte County Superior Court to enforce abatement orders and abate the nuisance question. November 28, 2018, code enforcement officer commenced the abatement nuisance, removed trash, debris, towing of abandoned vehicles, and basically completed the abatement process on that date. February 27, 2018, the notice of hearing and copies of the abatement report were mailed to the parties and posted on the property. Is that correct, Officer Melo?
Yes.
All right. Indicates the property is now in compliance and no longer a public nuisance. And that has been noted. Exhibit 3 is the cost of abatement report, which is broken down, and it's an itemized cost of receipts performing the work. For example, to the Waste Management Authority, California Auto Image for towing, Roto-Rooter, Curry Transfer and Recycling. I see that receipts have been attached to the cost recovery report. And it does, this report, cover the Wayne F. Garman, trustee of the Garman 2013 Trust. He gives a legal description of the property, which shall be noted with the document, date of the hearing. The invoice costs total $3,080.94. Under Del Norte County Code, the enforcement officer is entitled to request reimbursement for administrative costs. I see that the time has been 30 hours and 30.75 hours for court enforcement officer time, building maintenance staff, environmental health staff, county council staff, sheriff patrol staff. That totals $2,989.43. So I feel those two sums, which those two sums total, do you have that? I miss it here in the report. There's two sums. It's probably on the proposed order. Let's see. Oh, here it is. I do see it. Sorry. Those two sums total $6,000 $70.37, as documented by Exhibits 3 with its subsections. I noticed that there is a request for civil penalties under 8.440, the Del Norte County Code, which can be $100 per day from the date of mailing of the nuisance to date of compliance, which total of those costs could be, you have that figure right at handy, don't you know?
The maximum amount would be
Yeah.
$21,600.
All right. Thank you. And the request is for $2,160, which is extremely reasonable under the circumstances. All right. So exhibits 1, 2, and 3 shall be admitted into evidence and shall be kept by me until the appeal period is run on the cost recovery issues. A proposed order has been issued, or has been presented to me, and I'll take a moment to look at that, see if it needs any changes. All right, there's still no, is there anyone here on the 243 Olive Street, Lewayne, Garmin? No one present, so I will make my order at this time on the cost recovery after the hearing. It is a resolution confirming an accounting of costs of abatement of a public nuisance and authorizing a special assessment and lien to recover said costs of abatement. Whereas the hearing officer on 8/17/2018 confirmed the existence and conditions constituting a public nuisance at the real property known as 243 Olive Street, Crescent City, assessor parcel number 115-271-017, and gives a legal description, which I won't read now, but will become part of the record when this is filed. Whereas the property owner did cause said abatement of public nuisance on or about November 2018, November 28, 2018. Whereas Del Norte County Code Chapter 7.08, Article 9 authorizes the hearing officer to recover costs of abatement of public nuisance by special assessment and lien. And whereas the special assessment and lien must be authorized by resolution of the hearing officer. Whereas the hearing officer, having heard the evidence presented, may confirm or modify the accounting of the costs of abatement. Now therefore be it resolved, the hearing officer of Del Norte County, State of California, does hereby confirm the accounting of costs of said in the amount of $6,070. Resolved that said costs of abatement shall be special assessment and lien upon the property as described, a legal description. Be further resolved that the code enforcement officer of the County of Del Norte is hereby authorized and directed to sign the notice of abatement, lien, and special assessment and all other necessary documents for the levying and special assessment and abatement lien upon the property. Be it would further resolve that the notice of lien after recordation shall be delivered to the county auditor, who shall enter the amount of the lien on the roll as special assessment, and that was the $6,070.37. And I shall sign this 15th day of March 2019 as to this order, which becomes special assessment lien. And I will give this to the officer for the processing. Now, there was a request for $2,160 as cost recovery. No order has yet been provided for me to sign on that, and I suspect it will be. And when it is given to me, I shall sign the civil penalties under Code 8.440, that's Del Norte County Code for civil penalties. The request was $2,160. What I'm going to do is make that, just round it up to $2,000 for civil penalties, and I will sign that order. Is that clear, Madam Clerk? All right, thank you. Anything else on, did I cover everything on that, Officer Melo?
Yes.
The next matter on the calendar is regarding 5025 Wonder Stump Road, Scott DeVore, property owner. Anybody here on this matter? Would you just please step up to the front row here and have a seat there, and we'll call you in a second. I see that 2025 Wonder Stump Road, 1/18/2019 administrative hearing was held on public nuisance, regarding public nuisance on the property. Order was issued regarding that public nuisance, and was given 30 days to abate the nuisance. It was continued from time to time. Let's see, we had a date on February 22nd, 2019. We're here now for progress review. First, let me hear from Officer Melo. Where are we on this property for progress here?
Yeah, I followed up on site today, met with Mr. DeVore, and he's made some progress there, cleaning up, really consolidating a lot of the debris, getting it sorted and organized and prepared for throwing it away, or having the recyclers come out and collect some of them items. So definitely been some progress there.
All right, that's good to hear. We're making progress. Mr. DeVore, would you step up to the podium, please, and state your name, sir?
Scott DeVore.
All right. And you have the property at 5025 Wonder Stump, is that correct?
Yes, sir.
And how do you feel things are going along?
Not as fast as I'd like them to, but we're doing okay considering the weather and everything else, financial situation.
Do you have in mind how long do you think this is going to take to get substantial compliance?
Well, we're working on it right now as we speak. I'm getting ready to take the lid off the mobile home, and once the roof's off, we'll just take it right down. I can't really give you a date. All I can do is give you my best college try. And in regards to the last time I was here, you spoke and asked if I could work in the foul weather. I did, and I got sick. So you gotta give me a little room on that, if you would, please.
It's tough. I understand that. What's your thoughts, Officer Melo?
As long as Mr. DeVore keeps progressing, I'm happy to work with him. I understand there's a large amount of debris out there, so financially it's quite expensive. But he is doing what he can on site and taking what he can afford to the dump, so that's good progress as far as I'm concerned.
You think more than, want to review this in 60 days instead of 30, or do you want to keep a
I'd
close
prefer to do
handle on it?
30-day check-ins with him.
Absolutely.
Okay. Thank you for appearing, Mr. DeVore, and giving us an update. That's always encouraging, and I appreciate that. We'll continue this to April 19, 2019 at 2 p.m. Is that okay, Madam Clerk? All right.
Thank you, sir.
Thank you. Next matter on the calendar is regarding 43 Weber Drive, Klamath, and it's set for a nuisance hearing. Is there anyone here on 43 Weber Drive? All right, would you come forward and just first of all state your name and spell your name?
Haley Sutherland, and it's H-A-I-L-E-E and S-U-T-H-E-R-L-A-N-D.
All right. And are you prepared to go forward on the hearing today?
Sure. I don't know.
Okay, well, you can go ahead and, you're not asking for a continuance, that's what I'm,
Yeah, I need more time to get it, to comply with the list that I have to do and stuff. I don't know what I'm supposed to do.
well, no, that's fine, you're entitled to ask questions. What this is set for today is a hearing, and what would happen is Code Enforcement Officer Melo would present evidence, and I would look at it to see if in fact there is a public nuisance and what type of nuisance it is, and then you could present evidence or you could ask him questions, and then on that basis, and then you're entitled to present evidence to show basically that there is no nuisance, public nuisance. So that's what we're here for today, and that's what I'm prepared to do, and I think Mr. Officer Melo is ready to go forward and has evidence. Unless you can tell me, Ms. Sutherland, Haley Sutherland?
Yes.
That, you know, in 30 days or something, you'll have everything taken care of.
Yeah.
Is that what you're going to tell me?
Yeah.
All right.
Well, I don't know how long this takes to get approved for a permit. I applied for it, but I haven't.
Could you take a look to see what she has, Officer Melo?
She has the permit already for demolition.
All right. And do you think 30 days continuance would be good before we go forward, or do you think we want to, it's such of a large task that it's going to take some time, or do you think there's going to be substantial compliance within a short period of time?
Definitely supportive of some time extensions, but we would like to move forth with just confirming the nuisance conditions today if we can.
Okay, I think that's what we're going to do, because it's been my experience that when there's quite a bit of blight, junk, debris, etc., it takes quite a while to get this stuff done, and it just makes things easier when we have an order, and it actually puts you, you know, keeps you going to keep costs down and so forth. So what we'll do here is, why don't you just have a seat in the front row there, and I'll call you back up when we're ready for you. So we'll proceed with the hearing on 43 Weber Drive. Do you have any evidence to present, Officer Melo?
Yes, we have prepared a staff report, and then 3 exhibits attached to that. These are the property ownership information, some inspection photographs, and an issued notice of nuisance and other material.
All right, would you like to present those to me, please? Okay, I presented several documents, and they're marked as exhibits. And I'll go through these. Let's see here. Exhibit 1A is a letter, a staff report addressed to me, the hearing officer, from Dominic, Melo, code enforcement officer. The hearing date of March 15, that's today. And basically gives a summary of the problems at the property. As indicated, this letter is signed by Heidi Comstoll, Director of Community Development. Is that correct, Officer Melo?
Yes, the director has reviewed the documents.
All right. And in the summary, it says basically from 7 of July 2018 onward is that there's unsecured and dilapidated mobile home, trash inside and outside, abandoned boat, junk and debris, no building permit history. Unfortunately, is not good. There appears to be 5 prior nuisance cases. So is that kind of the gist of the situation, Officer Melo?
Yes.
Okay. Exhibit 1 is tax deed, purchase of tax default property from the County of Del Norte. Shows that the deed's been granted to Haley E. Sutherland and Andrew L. Sutherland as joint tenants. Gives a description of the property. Question. Exhibit 2, which has 37, I'm sorry, 37 photographs. I'll take a moment to look at all these. I guess you know what the property looks like?
Yes.
All right.
I just have pictures all the time.
Okay, I see mobile homes in a boat and like some furniture, couch, chair, whatever. Trash throughout, maybe an abandoned washer or dryer. The structure is exceedingly dilapidated with bags of trash outside, debris outside, inside. Looks like furniture dilapidation, extremely severe condition, bags of trash. Continues broken windows, substandard condition for sure. Again, more bags of trash, exterior, some and debris and trash not in bags also. Continuously a large amount of trash seems to be everywhere. Pictures are quite thorough in the depiction of the scene, the structures of the boat and vehicle. Exhibit 3 is a series of exhibits, subsections showing notice and receipt for those notices regarding notice to abate and notice to appear. description of the property, conditions. And your presence here today shows that you have received notice of that, is that correct? Yes. All right. And these exhibits I presented to you, Officer Melo, they've been marked in, did you personally prepare those for this hearing?
Yes, I did.
All right. And obtain the deed, et cetera, is that correct?
Yes.
And all right. These exhibits 1A, 1, Section 2, and all their subsections in Section 3 shall be admitted into evidence. Do you have anything else to offer on this, your case in chief?
You know, just obviously there's an extensive history at that property with it being in a nuisance condition, and it has been in the past declared a public nuisance as well, and that case has never been closed. When it went to tax auction, the notice of nuisance was recorded against the property. I don't know if Ms. Sutherland researched that prior or not. So there was a lot of forewarning that there was some issues there and pending enforcement action. So today we're kind of refreshing that, bringing the case back. And in the past, we didn't have the funding to abate the nuisance, sort of been dealt with quite a long time ago. Today we do have the funding available to address the matters there. Now just, you know, reapproaching the current property owner, seeing where they're at with it. And then also the other concern that code enforcement has is the property is listed for sale currently. Supposedly there's a prospective buyer, and the property's pending in escrow. So it may change hands here shortly too. So there's just kind of some things we need to work through to ensure that abatement happens and compliance is gained.
Thank you. All right, appreciate that. Helps fill the record. All right, this is your chance, Haley Sutherland, if you could step up here, and what I will do is swear you in first. Raise your right hand. Do you, first state your full name for the record.
Haley Sutherland.
All right. And do you solemnly swear or affirm that the testimony you are about to give in this matter now pending at this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
So help you God, you do.
Yes.
All right, thank you. And do you have any questions for Officer Melo on what he has indicated? Or any of the exhibits that were presented? Did you want to look at them or ask questions on them?
Do I have to clean the inside of the trailer if it's going to get demolished anyway?
Well, typically when we conduct abatement or demo of a structure, we do clean out the inside.
Okay.
But you know, some of that debris can go with it. You know, depending on who you hire as a contractor or you self-contract, kind of determine a lot of that.
Okay.
Do you have any evidence to present on your behalf?
Yeah, I was up there today cleaning stuff.
I'm sorry?
I was up there today cleaning up the front, so the front looks good now, but, and I got this permit, or so it's already, is it granted once they give me this? Okay.
Can I?
Okay.
The permit is for demolition?
Yeah,
Could you take a look at it and see?
and then I got, do you want to see pictures or can you not?
Yes, I'll take a look at those.
And they're, the boat, I think they're supposed to be, but once it is.
There's been lines, obviously, trash, but the boat you think you're going to sell?
The neighbor might just take it, I might just,
Okay.
I might not hold it.
That structure looks substantially dilapidated, and you're going to have that demolished?
Well, hopefully it gets sold, but they're, the people that are, the buyers are gonna tear it down too, and I don't know what they're gonna put something else in there.
All right. Glad to see you have some working on this is maybe the best way to. I will note for the record, since you don't have copies but of those photos, but I will note on the record that I have looked at what, maybe 3, 6, 9, 12, 15 of them or something.
Yeah, I think there's 16 on this. I'll print them out. Can I bring
No,
them?
that's okay.
Okay.
And it looks like there's been some compliance on the debris. However, the structures problem is obviously still there.
Yes.
Do you have anything else to offer at this time?
Can I get, because it says something about if I don't comply, it's gonna be like $100 a day, or it could be $100.
That happens at the very end, where I'll make a determination. I'll hear from what the code enforcement officer thinks is appropriate. Many times I do not give a civil penalty, particularly if things have moved along very nicely and there's been compliance in a fairly forward-moving fashion. But you would still be subject to reimburse the county for actual costs they put in and to clean up the mess, if any, and administrative costs and time. But that would be at another date down the line.
Okay, we're not there yet.
After there's been compliance with, you know, that means everything's cleaned up and taken care of.
I can get that done.
Okay, so if there's nothing else, then I will make a ruling. If you'd like to sit in the first row, you can.
Okay.
As I indicated, the exhibits are entered into evidence and will be kept by me until the appeal period is run, and then they'll be returned to the code enforcement officer. I do find that there's a notice to abate and notice to appear for the nuisance hearing has been given per Del Norte County Code, and the owner of the property in question is Haley Sutherland, and property is in Del Norte County. I do find by a preponderance of the evidence that there is a public nuisance at said property, and that's preponderance of the evidence is basically just 51%, so it doesn't take much to show a nuisance issue, and that at this time the nuisance has not been abated, and obviously there's health, safety, and welfare matters of concern. And there's been a proposed order, and I'll take a moment to look at this, see if I need to make any changes. All right. Findings in order after hearing, 43 Weber Drive, Klamath, Del Norte County. On 3/15/2019, an administrative hearing was convened pursuant to the authority of Chapter 7.08 of Del Norte County Code. The undersigned hearing officer finds that Haley and Andrew Sutherland, the real property owners, were notified of the hearing to show cause why conditions of the property at 43 Weber Drive, Klamath are not a public nuisance. Said property is more fully described in the exhibit attached to the order. Present, obviously, were me, was the hearing officer, Code Enforcement Officer Dominic Melo, and Haley Sutherland. The Undersigned hearing officer specifically heard and considered all relevant evidence and received testimony from Officer Melo to the public nuisance alleged at the property, and I should also indicate Haley Sutherland. Based upon the sworn testimony and the evidence presented, that there is a finding of a public nuisance, and that does exist, and there is sufficient cause to remove or abate the same. And the public nuisance is described as follows. Violation of Del Norte County Code 7.08.310, subsection 11, the accumulation of abandoned, wrecked, or disabled, dismantled, or inoperative vehicle parts. Initial that. A violation of Del Norte County Code 7.08.310, subsection 8A, any condition that constitutes a visual blight, accumulation of junk, trash, debris, scrap metal, rubbish, packing material, that type of stuff. Dilapidated residential structure on the property constitutes an attractive nuisance. Those objects or conditions that by their nature may attract children or other curious individuals per County Code 7.08.310, subsection 7. Conditions on property is in a state of unsightly condition and dangerous condition, so as it constitutes a blighted condition detrimental to the property values in the neighborhood per County Code 7.08.310, subsection 6. Any vacant, unoccupied, or abandoned buildings or structure that is not reasonably secured against uninvited entry, or the state of unsightly conditions or dangerous conditions as constitute a blighted condition detrimental to property values per section 7.08.310, sub 6. Storage of 200 or more square feet of the area of any lot or structure, or keeping junk, scrap metal, or other scrap materials. Violation 20.04.420. Junk, household trash, and debris on the property, unsightly and visible blight per 7.08.310, subsection A. Property conditions likely to or does harbor rats or other vectors or vermin. Violation 7.08.310.17. Any building or other structure which by reason of rot, weakened joints, walls, floors, underpinnings, roof ceilings, insecure foundations, or other cause has become dilapidated or deteriorated per 7.08.310, sub 15. Maintenance of any use of real property in violation of any provision of Del Norte County Code, state law, or federal law. Violation of Del Norte County section 7.08.310.13. Overgrown vegetation which is unsightly and likely to harbor rats or other vermin, etc. 7.08.310.8F. Abandoned, discarded, or unusual objects or equipment, or such as furniture, stoves, appliances, refrigerators, freezers, cans or containers, automotive parts and equipment, etc. Violation of 7.08.310.8B. Any condition that constitutes a visual blight. For purpose of this code, visual blight is any unreasonable or unlawful condition or use of real property, premises, or building exteriors which by reason of its appearance is viewed as a ground level from the public right-of-way or from neighboring premises is detrimental to the property of others or to the value of property in the neighborhood. Visual blight includes but not limited to keeping, storing, depositing, scattering over or accumulation on premises. Violation 7.08.310.8, sub 8. Any condition that constitutes an attractive nuisance, those objects or conditions that may result way to attract children or curious individuals, or 7.08.310, sub 7. Okay, as to the time to give Ms. Sutherland opportunity to abate, that is to take care of all these problems, how much time would you like, you think is reasonable under the circumstances?
I'd like to hear what Ms. Sutherland has planned, and then we can go from there.
How much time do you think you'd need to, 30 days, 60 days, 90 days?
60 days would be good.
I'm sorry?
60 days would be good.
60 days? I think that's reasonable.
Yes.
Okay. Okay.
Does the fence have to be demolished in 60 days?
The hearing officer hereby orders the property owner as reasonable, or let me clean this up here. To abate the nuisance within 60 days of today's date.
Can I have 90 days? He says it has to be demolished or repaired.
She was asking if she has to demolish it or have the option to repair it, so it's either or.
The pictures I saw, it seems like you're going to be wasting money trying to repair it to get up to county code.
No, can I have
For, you know, I mean, if somebody's going to live in it, that is water, sewer, electrical, and habitability is pretty high benchmarks, and it looked to me like it may save you money to knock it down, but
Can I have 90
I'll
days?
hear from you. What, 90 days?
To knock, to have to have it done by then.
Okay. I'll change that to 90.
Right.
Could we keep it at 60 and have her report back, and then if she's made progress in that 60?
I have no more room in that square, so
Gotcha.
I'm sorry. It's now 90.
Yes.
You
Okay.
have to live with it. We'll do 90. You promised to have some, keep going, and appreciate, like
I don't want
said,
to bill. I don't want to bill from the county.
Well, you may get something, but you're certainly, by doing this, you're going to save yourself a lot of time, energy, and money. If the abatement of the nuisance is not commenced or prosecuted within this 90 days of today's date, enforcement officers shall be empowered and authorized to abate the nuisance. And this decision becomes, is final. There's a review process if you want to, and that's 90 days under Civil Code of Procedure 1094.6, and I have to advise you of that. And what you have to do here is what's recommended to take care of the problems is to remove and properly dispose of all solid waste, trash, junk, debris, accumulations, properly cut, mow, or prune as necessary to eliminate all overgrowth of vegetation. All dilapidated or unsafe buildings shall be demolished or rehabilitated, and I'm going to leave that up to you, but you're going to have some big costs in rehab. All dilapidated or unsafe buildings and structures shall be vacated and secured against entry until they are either demolished or rehabbed. So that's what the abatement process shall consist of. By the way, you'll get a copy of this order.
Okay.
Furthermore, the owner shall be responsible for paying the county's costs pursuant to Chapter 7.08 of Del Norte County Code, including but not limited to the cost of abatement and cost of administration, as well as any civil penalties assessed by the hearing officer, should there be any, 7.08.440. Once the nuisance is abated, a hearing will be held to review the costs of accounting and proposed penalties. And you can appear at that and be heard, and give your opinion on costs and so forth. A copy of these findings and orders shall be served on the owner of the property in accordance with Del Norte County Code. In addition, a copy of the findings and orders shall be forthwith conspicuously posted near the property. And this is becomes final subject to judicial review in accordance to California Code of Civil Procedure 1094.6. I shall date this 3/15/2019 and signing the order as of now. And I shall give this order to the hearing officer for, the code enforcement officer for the processing. And that should be it, unless you have anything else?
Nope.
Okay. Thank you for appearing. As I indicated, so many people don't, and they regret it later.
Yeah. I
Okay?
didn't know that what happened to the one.
Okay, thank you. Next on the calendar, I'll take these here, put these over here. Oops. Try to keep these all separated. Okay. Quick drink of water. Next, number 4. Regarding 400 Frosty Lane, property owner Robert Madden, regarding a nuisance process, a nuisance set for a nuisance hearing. Anyone here, Mr. Madden here, or anyone on Mr. Madden's behalf? I see no one present in the audience, so that would be a no. Are you prepared to go forward with a nuisance hearing today?
Yes, we are.
Okay. Do you have some evidence to present, sir?
Yes, I have a staff report with 3 additional exhibits, property ownership information, issued notices, and inspection photographs.
All right. You can process your work. All right. I've been handed several documents marked with exhibit numbers. Exhibit 1A is a staff report addressed to me, the hearing officer, from Code Enforcement Officer Dominic Melo regarding the property at 400 Frosty Lane, Crescent City, and it's dated for this hearing March 15, today's date. And let's see here, this staff report certainly gives a summary of what's been happening on the property. It is signed by Community Development Director Heidi Kunstl, and is that correct? She's had an opportunity to review this staff report.
Yes, she has.
Thank you. As I see here, basically from April 27 on going forward here is that April of 2017. There's been illegal dumping, abandoned mobile homes, substandard, extreme level of dilapidation, structure, like 100 junk tires, abandoned vehicles, cars and boats, trash and debris, blighted conditions. And then in 2018, illegal dumping with recreational vehicles, furniture, tires, all in violation of Del Norte County Code and other appropriate sections. There's okay. Can you, while we're looking at this, Officer Melo, you have been sworn in previously.
Yes.
Can you Give us an update on the, since nobody has appeared on this, can you give us an update on notice of not only the nuisance, but also the hearing, please?
In regard to contacting the property owner?
Yes.
Yeah, so since I've been dealing with this property, I've never been able to locate a property owner. The addresses that the assessor's office and tax collector have on hand are no good, and so we ended up posting the notices at the property under county code. We've done just a little bit of research online and have possibly located another address, and we'll follow up with that.
All right, thank you. And the staff report seems to indicate there's properties in tax default also.
Yes, since 2013.
Okay. All right. Exhibit 1 is a interspousal transfer grant deed. Appears to transfer the property from Laura Madden to Robert F. Madden, non-married man, that's sole and separate property. And this gives a legal description. Did you obtain this deed from the county offices?
Yes, from the recorder's office.
All right. Exhibit 2 is the 15 subsections. Is letters to a Robert Madden, 400 Frosty Lane, concerning the notice of nuisance and order to abate, along with the statutory notice to abate nuisance and notice to appear forms, and as required by Del Norte County Code. Exhibit 3 with subsections are some 20 photographs. I'll take a moment to look at those. I see. Did you prepare these photographs, Officer Melo?
Yes.
And those fairly depict what the property, at least at the time of the photographs, condition at 400 Frosty Lane?
Yes, they do. And
I see appears to be an accumulation of trash, debris. It looks like a boat in substandard condition. Property. Numerous vehicle tires, rubber tires. Many of those scattered about. Again, loose debris, junk. Looks like furniture and furnishings, chairs and pillows and whatnot, that type of stuff, loose in the property, perhaps in a pile and scattered about. Some metal debris and other debris. More photographs of what appears to be an abandoned boat and an abandoned recreational vehicle with debris, lots of debris scattered around it. There's another, apparently an RV, which is extremely dilapidated, extremely bad condition. More debris. Again, tires and other trash. And structures in dilapidated, obviously dilapidated condition. These exhibits 1A, 1, 2, and 3 with their subsections shall be admitted into evidence, and I shall secure these exhibits until the appeal period has run, and then I shall return them to the code enforcement officer. Do you have any other evidence to present?
Not currently, no.
Okay, thank you. And as indicated, there is no one here on behalf of, there's no one here, either Robert Madden or anyone on his behalf. And so I will make my findings and conclusions based on the evidence. Notice to abate, notice to appear for news hearing has been given as required by Del Norte County Code. The owner of the property is shown by grant deed is Robert Madden. The property is located in the County of Del Norte. By a preponderance of the evidence, there is a public nuisance in said property, and nuisance has not been abated, and obviously a health, safety, and welfare issue for the County of Del Norte. There has been a proposed order, and I'll take a look at that to see if any changes should be made. All right, I'll go ahead and read through it. On 3/15/2019, an administrative hearing was convened pursuant to the authority of Chapter 7.08 of Del Norte County Code. The undersigned hearing officer finds that Robert Madden, the real property owner, was notified of the hearing to show cause why conditions of the property, 400 Frosty Lane, Crescent City, are not a public nuisance. Said property is more fully described as Exhibit A, which is attached to the this order. And present at the hearing were myself, the hearing officer, Robert Russell, code enforcement officer, Dominic, Melo, and no other persons, period. The undersigned specifically heard and considered all relevant evidence and received testimony from Officer Melo to the public nuisance alleged at the property. Based upon sworn testimony of Officer Melo and other evidence presented, the undersigned finds that such public nuisance does exist and there is sufficient cause to remove or abate the same. I'll go through the evidence shown as per county code and others. The public nuisance is described as follows. Violation Del Norte County Code 7.08.310 sub 11, the accumulation of abandoned, wrecked, disabled, dismantled, or operated vehicle parts. Violation Del Norte County Code 7.08.310 sub 8A, any condition that constitutes the visual blight, accumulation of junk, trash, debris, scrap metal, rubbish, packing materials, etc. Dilapidated residential structures on the property conditions constitute an attractive nuisance. Those objects or conditions that by their nature may attract children or other curious individuals per County Code 7.08-310 sub 7. Conditions of property in a state of unsightly conditions and dangerous conditions so as to constitute a blighted condition detrimental to the property values in the neighborhood. Property also detrimental to the health, safety, and welfare per County Code 7.08.310 sub 6. Any vacant, unoccupied, or abandoned buildings or structure that is not reasonably secured against uninvited entry or in a state of unsightly condition, a dangerous condition, so as to constitute a blighted condition, detrimental to property values in the neighborhood per Del Norte County Code 7.08.310 sub 6. Storage of 200 or more square feet of the area of any lot of storage or keeping of junk, scrap metal, other scrap net materials, violation of Del Norte County Code 20.04.420. Junk, household trash, debris, other property, unsightly and visual blight per 7.08310 sub 8. Property conditions likely to or does harbor rats or other vector or vermin per 7.08310 sub 17 per Del Norte County Code. Any building or other structure which by reason of rot, weakened joints, walls, floors, underpinnings, roof ceilings, or insecure foundation or other causes has become dilapidated or deteriorated per Del Norte County Code 7.08310 sub 15. Maintenance or use of any real property in violation of any provision of Del Norte County Code, state or federal law, violation of section 7.08310 sub 13. Overgrown vegetation which is unsightly and likely to harbor rats and other vermin per Del Norte County Code 7.08310 sub 8F. Abandoned, discarded, or unused objects or equipment such as furniture, stoves, appliances, refrigerators, freezers, cans, or containers, automotive parts, equipment, etc. in violation 7.08.310 8 sub B. Any condition that constitutes a visual blight, for instance, visual blight for purposes of this code. Visual blight is any unreasonable or unlawful condition or use of real property, premises or building exterior which by reason of its appearance as viewed at ground level from the public right of way or from neighboring premises as determined by property of others, values, detrimental, etc. Visual blight includes but is not limited to keeping, storing, depositing, scattering over or accumulation of the premises per Del Norte County Code 7.08.310 sub 8. Any condition that constitutes an attractive nuisance, those objects or conditions that by the nature of any that may attract children or other curious individuals per Del Norte County Code 7.08.310 sub 7. Officer Melo, do you have an indication of how you want to proceed as to time limits to abate this, or do you think it's going to be a waste of time, or what's your thoughts on that? Do you think, I guess I'd like to know if you think we're going to ever get a hold of Mr. Madden to get some serious compliance done.
I don't believe I'll be able to locate him, but we did just within a couple days ago located one possible address. But at a minimum, I'd like to be able to send the findings in order there in addition to posting them at the property. But it is one of our most horrific sites that I'm aware of in the county, so I don't want to delay too long. I would recommend a 30-day order.
Okay. Okay, the hearing officer hereby orders the property owner to abate the nuisance within 30 days of its date if the abatement or a nuisance is not commenced or prosecuted within 30 days of today's date. The enforcement officer shall be empowered and authorized to abate the nuisance. My decision is final, subject to judicial review in accordance with California Code of Civil Procedure 1094.6. An abatement shall consist of the following actions. 1, remove and properly dispose of all solid waste, trash, junk, debris, properly cut, mow, or prune necessarily to eliminate all overgrowth vegetation. All dilapidated and unsafe buildings shall be demolished or rehabilitated. all dilapidated or unsafe buildings and structures shall be vacated and secured against entry until they are either demolished or rehabbed. Remove all lawfully stored or inoperative vehicles. Furthermore, the owner shall be responsible for paying the county costs pursuant to Del Norte County Code 7.08, including but not limited to costs of abatement, costs of administration, as well as any civil penalties assessed by the hearing officer per 7.08.440. Once the nuisance is abated, a hearing will be held to review the costs, accounting, and proposed penalties. The owner may appear and be heard on questions whether the accounting and costs included are accurate and reasonable. A copy of these findings and order shall be served on the owner of the subject property in accordance with provisions of Del Norte County Code. In addition, a copy of the findings and order shall be forthwith conspicuously posted on or near the property. The decision of the hearing officer shall be final, subject to judicial review in accordance with California Code Civil Procedure 1094.6. I will date this 3/15/2019 and sign it. And it does have the attached grant deed giving a legal description of the property. And I give the order back to the code enforcement officer for processing. All right. Making some progress here. All right, let's see, we have down to 5. 155 Megan Lane, 155 Megan Lane. Property owner Kevin Fugate, F-U-G-A-T-E. I would call the name, but there's nobody in this proceedings except us working. So this is set for a progress hearing. Is that correct, Officer Melo?
Yes.
Let's see here. Okay. I see that on 12/21/2018, a hearing was held on public nuisance complaint. There was an order, there was a public nuisance, and order to abate within 30 days. I see we had reviews on 1/18/2019 and 2/22/19. And I don't recall if anyone appeared on those dates, Officer Melo, but if you recall, fine, you can tell me what happened or what is the status of that property as of today.
I think we've only had an appearance at the last hearing. The other hearings weren't able to make it.
Oh, okay.
No, but anyway, the property has changed hands, and Mr. Fugate is the new owner, and he's actively working on demolition as we speak. I was out there this morning, and they've crushed some of the substandard structures already. They've cleaned out the dilapidated modular already, and then they've got a 30-yard debris box on site. Also, cost recovery has been effected up to this point, so all of our direct costs have been collected. I would recommend removing the case from the calendar, as it's basically on the path to compliance.
All right, and you don't, and he's taking care of costs
Yes, they're
so you see no need for the hearing officer to
not at this point.
Review and okay. What happens if there is turns out to be no substantial compliance, or we
would
file another?
Yeah, I'll keep the case open, and then if they fail to comply, then I'll just issue another notice to appear, and we can resume from here. Otherwise, if they follow through, he's promising next week the site will be completely clean. At that point, I would close the case.
Okay, and you don't see a cost recovery hearing coming out of it?
They've already paid our direct costs up to this point.
Okay, that's very good to hear. So on recommendation of Code Enforcement Officer, Madam Clerk, you can remove this from the calendar, active calendar, unless there's a reason to put it back on the active calendar. That'll be done by the Code Enforcement Officer. Okay, next one in order. Let's see, we did Mr. Sutton already, so we're down to number 7. And that's 760 Indert Street, Crest City area. Property owner Nicholas Barczyk, and it was set for a nuisance hearing. Are we ready to proceed on this?
Yes, county's ready to move forth with the case.
Okay, as indicated, there's no one in the audience, so I won't even call the name. No appearance by Nicholas Barczyk, or obviously anyone who may be representing him. So, excuse me, if you have some evidence to present, we can go ahead and do it.
Yes, they have the staff report outlining the case history and current happenings at the property, and 6 additional attachments ranging from mailed notices, issued notice of nuisances, inspection photographs from 2 different dates, and also a neighbor complaint.
Exhibits, and see what we. Okay, as indicated, this is on 760 Indert Street, regarding public nuisance. There's no one present for the property owner. I've been handed staff papers, which are marked as exhibits, and I shall go through these and let's see where we are. Exhibit 1A. Staff report prepared from Dominic Melo, Code Enforcement Officer, for this hearing date of March 15, 2019. Regarding 760 Indert, Crescent City area. Let's see here, this appears to be a summary of what's been going on. This is a staff report currently signed by Community Development Director, who has reviewed this. Is that correct?
Yes, yes it is.
Okay, and it appears that January and forward of this year, 2019, that there's a recreational trailer on the property, and there's been problems for maybe 7 years or more. It's a corner lot. There's an intersection there. Perhaps an unlawful occupancy going on. There's junk trash, debris, vegetation, overgrowth, violation of zoning setbacks. And there's again a park on the trailer. More trailers parked on property, perhaps some habitation going on. There's no water or sewer hookups. Appears to be some history here with at least 4 prior code violations. Is that kind of a summary of the process, Mr. Melo?
Yes.
Could you, since we don't have anyone present here, could you explain either the mailing and or posting of this property as to the notice of public nuisance requiring abatement and the notice for today's hearing? Could you explain for the record, please?
Yes, and in our efforts to serve the notice of nuisance, certified mail and first-class mail, once again, we have a bad address. It's not up to date, and the post office returned those unable to forward, no longer at that address. I have done some research and located a second possible address, which we did send out some certified mailings and first-class mail. We haven't received any of those back, so that's an indication that they're not going to be recepted or have gone through. So I went ahead and posted on the property per county code.
All right. And thank you. Exhibit 1 appears to be a quick claim deed from a Vernon Smith to a Nicholas Todd Barrack, B-A-R-C-H-A-K. Did you obtain this from the Del Norte County records, Officer Melo?
Yes, I did.
Okay. Does give a property address at 760 Indert. Exhibit 2 is a letter dated January 28, 2019 to a Nicholas Todd Barrack at a P.O. Box in Bridgeville, dated January 28, 2019, regarding the problems of public nuisance and abatement requirements. And exhibit 3 is it's some 17 pages of exhibits, shows certified mail request and a letter 2/25/2019 to that P.O. Box 91 in Bridgeville, California, to a Nicholas Barrack. And another letter to Nicholas Barrack at the P.O. Box 1907, Redway, California. And with attachments regarding notice to abate nuisance and notice to appear required by Del Norte County Code as exhibits 9 of Eric. All the attached exhibits up to 17. And a legal description of the property in question. And this exhibit's been supplemented by Officer Melo's indication of how that mailing and posting notices have been done. Exhibit 4 with 7 subsection photographs. Should go through these. Shows mobile home with a tarp laying down. A fence posed to be extremely close to the curb or street. Shows photo with 2 mobile homes, another with overgrown vegetation, another photograph showing the mobile home right near the street corner, entered street. Appears to be posting on the fence. And another showing conditions of overgrowth in Peddler Avenue, street corner intersection. Exhibit 4, Exhibit 5. shows very close mobile homes, almost right on the curb line, and overgrowth, again, vegetation. That's 2 exhibits, 5. Exhibit 6 is a letter addressed for the March 15, 2019 hearing, to whom it's concerned. I'll go ahead and read it. It's from a Ron and Debbie Mayhew, 2613 Quinlan Avenue, Crescent City. Officer Melo, did you receive this in due course of your investigation?
Yes, I did.
Right. It says, this letter is in regards to the property at 760 Endard Street, Crescent City. This property has been continuous nuisance in our neighborhood for at least 10 years. It began with a fifth wheel that was placed on the raw property, no surfaces, and then promptly abandoned. Property is overgrown with blackberry bushes, which makes this a perfect hidden gem for illegal activity. Other fifth wheel vehicles and motorhomes have been placed on the property, next to the property, and are often lived in. Not only has the property been on an eyesore in our community for many years, but creates an unsafe condition for the residents. Vehicles are often parked illegally in this intersection, and which has no stop sign in either direction. Law enforcement tells us they have a difficult time helping clean up the continual problem with RVs on the road. They need a code that they can enforce. We would appreciate any assistance we can get during this property, regarding this property. All right. All right. These exhibits 1A through 6 will be admitted into evidence and will be kept by me until the appeal period is run, and then they'll be returned to the code enforcement officer. Officer Melo, is there anything you want to supplement here as issues that may have not been covered?
Just to reiterate that the property is currently being squatted upon. We don't know if they're trespassing or if they have permission from the property owner. This property has a long history of that. There's been issues in the past of them dumping their gray water out into the street. So it's potentially possible, happening now as we speak. So I think there's some urgency in addressing this issue.
All right, thank you. All right, I'm prepared to make my findings and conclusions based on the evidence presented. Notice to appear for nuisance hearing has been given per Del Norte County Code. The owner of the property in question, per the deed, as an exhibit, shows Nicholas Barchak, B-A-R-C-H-A-K, at 760 Endard Street, and legal description of that property has been given. The property is in the county of area of Del Norte County. I do find by a preponderance of the evidence there's a public nuisance at said property, and the nuisance has not been abated, and it's clearly a health, safety, and welfare issue for Del Norte County and its citizens. A proposed order has been presented to me regarding findings and the order after the hearing. Take a moment to review that, see if any changes need to be made. Okay. read the findings in order after hearing regarding 760 Indian Street, Crescent City area. On 3/15/2019, an administrative hearing was convened pursuant to the order of Chapter 7.08 of Del Norte County Code. The undersigned hearing officer finds that Nicholas Barchak, it's B-A-R-C-H-A-K, the real property owners, was notified of the hearing to show cause why conditions of the property, 760 Indian Street, Crescent City, are not a public nuisance. Said property is more fully described in the attached Exhibit A, which is included by reference in part of this order. Present at the hearing were myself, code enforcement, and myself, Robert Trussell, hearing officer, and code enforcement officer Dominic Melo. The undersigned specifically heard and considered all relevant evidence and received testimony from Officer Melo to the public nuisance alleged at the property. Based upon the sworn testimony of Officer Melo and upon the evidence presented, the undersigned finds that such alleged public nuisance does exist and there is sufficient cause to remove or abate the same. Public nuisance is described as follows. Violation Del Norte County Code 7.08.310, sub 11, the accumulation of abandoned, wrecked, dismantled, disabled, or inoperative vehicles. Violation Del Norte County Code 7.08.310, sub 8A, any condition that constitutes a visual blight, accumulation of junk, trash, debris, scrap metal, rubbish, packing materials. Camping, lodging, a recreational vehicle in excess of 14 excessive days, a 30-day period. Recreational vehicles on this property being used in violation of County Code 7.08.310, sub 6. Condition of property in a state of unsightly condition and dangerous condition so as to constitute a blighted condition, detrimental to property values in the neighborhood. Property also detrimental to health, safety, and welfare to the public pursuant to Del Norte County Code 7.08.310, sub 6. Any vacant, occupied, or abandoned building or structure that is not reasonably secured against uninvited entry or in the state of unsightly condition and dangerous condition so as to constitute a blighted condition detrimental to property values in the neighborhood. Property also detrimental to health, safety, and welfare of the public. Del Norte County Code 7.08.310, sub 6. Storage of 200 or more square feet of the area of any lot for storage or keeping junk, buildings, scrap metals, or other scrap. Violation Del Norte County Code 20.04.420. Junk, household trash, debris, and other property is unsightly and visual blight. Violation Del Norte County Code 7.08.310, sub 8. Property conditions likely to or does harbor rats or other vector or vermin. Violation Del Norte County Code 7.08.310, sub 17. Any building or other structure which by reason of rot, weakened joints, walls, floors, underpinnings, roof, ceilings, or insecure foundation or other cause has become dilapidated or deteriorated. Violation Del Norte County Code 7.08.310, sub 15. Maintenance or use of any real property in violation of any provision Del Norte County Code, state law, federal law, in violation Del Norte County Code 7.08.310, sub 13. Overgrown vegetation which is unsightly and likely to harbor rats or other vermin. Violation Del Norte County Code 7.08.310, sub 8, sub F. Abandoned, discarded, or unused objects or equipment such as furniture, stoves, appliances, refrigerators, freezers, cans, containers, automotive parts, and equipment. Violation 7 Del Norte County Code 7.08.310, sub 8B. Any condition that constitutes a visual blight. For purposes of this code, a visual blight is any unreasonable and unlawful condition or use of real property, premise, or building exteriors which by reason of its appearance is viewed at ground level from the public right-of-way or from neighboring premises is detrimental to the property of others or the value of property of others, offenses to the senses or reduces the aesthetic appearance of the neighborhood. Visual blight includes but not limited to keeping, storing, depositing, and scattering over accumulation of premises, violation of Del Norte County Code 7.08.310.7.8. Any condition that constitute an attractive nuisance, those objects or conditions that by their nature may attract children or other curious individuals, violation of Del Norte County Code 7.08.310.7. Unlawful storage or recreational trailer in front yard setback, violation of Del Norte County Code 20.48.60 sub 8.1 A1. Officer Melo, as to a time frame to abate, what's your thought process on this?
Need the opportunity to just post on site and wait and see if we're going to get a response from the property owner. But I think 30 days is sufficient to achieve that.
Okay. I agree. I'll keep a close handle on this one, see if we get any response from anyone. The county's going to end up having to deal with it themselves. Okay, the hearing officer hereby orders that the property owner is to abate the nuisance within 30 days of today's date. If the abatement of the nuisance is not commenced, prosecuted, or completed within 30 days of today's date, the enforcement officer shall be empowered and authorized to abate the nuisance. My decision is final subject to judicial review in accordance with California Code Civil Procedure 1094.6. The abatement shall consist of the following. Number 1, remove and properly dispose of all solid waste, trash, junk, debris accumulations. 2, properly cut, mow, or prune as necessary to eliminate all overgrowth of vegetation. 3, all dilapidated or unsafe buildings shall be demolished or rehabilitated. 4, all dilapidated or unsafe buildings and structures shall be vacated and secured against entry until they are either demolished or rehabilitated. 5, remove to lawfully store. Let's see here. That just doesn't make sense here. Number 5. Remove or lawfully store instead of just should make it or. Remove or lawfully store all unoperated vehicles. There we go. Furthermore, the owner shall be responsible for paying the county's costs pursuant to Chapter 7.08 of Del Norte County Code, including but not limited to cost of abatement, cost of administration, as well as any civil penalty assessed by the hearing officer pursuant to 7.08.440. Once the nuisance is abated, a hearing will be held to remove the costs, to review the costs, accounting, and proposed penalties. The owner may appear and be heard. Questions whether the accounting and costs included are accurate and reasonable. A copy of these findings and orders shall be served on the owner of the subject property in accordance with provisions of Del Norte County Code. In addition, a copy of findings and orders shall be forthwith conspicuously posted on or near the property. The decision of the hearing officer shall be final subject to judicial review in accordance with California Code Civil Procedure 1094.6. I shall date this order 3/15/15 and sign it. And attached to the order is the quitclaim deed showing property owner. And I shall return this to the enforcement officer for processing. And now we are down to, I think, the last one, right? Last on the calendar, number 8 is 6661 Lake Earl Drive, Peter Sterling, AKA Alan Hartley, regarding a progress hearing after order on public nuisance to abate that issue, rather. Let's see there. Let's see, we're set for a review. I see that on July 20, 2018, administrative hearing was held and order was issued regarding public nuisance with 30 days to abate. I think we've had 6 status reviews. Where are we on progress on this case? What's your recommendations, Officer Melo?
Yeah, I finally caught up with the property owner. He's been a difficult man to track down, but he's apparently terminally ill on oxygen, so he's having a rough time. He said he was going to turn the properties over to his daughter to manage eventually here. But anyway, he is wanting to rebuild the laundry room, not demolish it. And the last contractor he reached out to was apparently too busy or something, so he's got some other ones he's going to reach out to locally and try to get that going, and that would be the ideal solution. So we're supportive of that. Want to work with him, give him another 30 days to try to get something lined out.
How much time would you like?
30 days, please.
Okay, we'll set this for April 19, 2019 at 2 p.m. for review of the status on the abatement orders. Have that, Madam Clerk. April 19 for review. Is that a wrap?
That is it.
Great. That was a long hearings. Whoops. And but I think we got some things done.